Welcome to week 8 of American government. Last week we talked about Article 2 in the presidency. This week we're moving on to Article 3, where we'll talk about the judicial branch and the Supreme Court. And you know what? It's almost Halloween, so I think I'm going to do this in costume. That's right, ladies and gentlemen. Judge Lucas is in the house and class is in session. Yeah, so this rubber mallet's not actually a gavel, and this obviously isn't a real judge's robe. It's my high school graduation robe. But the knowledge I'm about to drop on y'all today is real. You've heard me reference these guys throughout class all year, and I know for a fact in history class you'd learned about the Supreme Court in cases like Plessy versus Ferguson and Brown versus Board. But what the heck do these people actually do? What really is the Supreme Court's purpose? The Supreme Court is established in Article 3 of the Constitution. And as you can see here, Article 3 of the Constitution really isn't that big at all. Unlike previous weeks where I broke down each clause and each section, I'm really just going to give you a broad overview of Article 3 this week. So Article 3 establishes the judicial branch of the United States government. And if you remember from the beginning of the year, I mentioned the judicial branch is the branch of government that interprets the law. Later on, I also mentioned that under the Articles of Confederation, there wasn't a separate judicial branch. If there was ever a conflict between the states, then Congress would kind of serve as judge as well. But there were some that thought that with this new government under the Constitution, the judicial branch should be its own separate branch. So in Article 3 of the Constitution, they create the judicial branch. And the judicial branch is actually made up of a ton of different courts. There's inferior courts or appeals courts, where you can take a case from the state courts and then it can work its way up the ladder all the way to the top court in the land, which is called the Supreme Court. So the Supreme Court has the function of determining if a law is legal or illegal. You might be saying, wait a second, Mr. Lucas, how can a law be illegal if it's the law? Well, just as a police officer can determine if you are acting legally or illegally according to the law also gets put up to scrutiny with the Constitution to determine if the law is actually fair. If something is considered constitutional, that means it's fine. That means it goes along with whatever the Constitution says and doesn't go against it. Because believe it or not, Congress and the president have both been known to pass laws that increase their power to the point where they actually can abuse the rights of Americans. So the Supreme Court serves as like a referee or an official, and they make sure that the game is being played fairly. They serve as a really important check and balance to the other two branches of government. And just like real referees, they always make someone upset whenever they make a call. Believe me, I should know. Being a referee was my first job. However, I don't think Supreme Court rulings get people to break their TVs quite like referees in the NFL do. The Supreme Court also helps settle disputes and conflicts that might arise over how a law should be interpreted. Because let's face it, two different people could be reading the same word or the same sentence and interpret it in two different ways. And so if there's ever confusion over what a law means, the Supreme Court is there to help settle that confusion. The Supreme Court is there to set the record straight and determine what the meaning actually is so that everyone can move forward with an understanding of what the law actually means. Otherwise, you'll continue to see people get confused over wording and have different interpretations, leading to situations like this. So if nothing I just said made any sense to you, let me allow Justice Sotomayor and Sesame Street to explain it to you.
Hi. Hey, I heard that there was a Supreme Court justice on Sesame Street.
There is, Baby Bear. There is.
Hi, Baby Bear. I am Supreme Court Justice Sonia Sotomayor, but you can call me Justice.
Now, to be clear, what does a justice do again?
A Supreme Court Justice is a judge who solves arguments by giving his or her opinion.
Look at that. Y'all are almost adults and Sesame Street's still coming in clutch for you. Now, we've gone over the qualifications for president and for members of Congress, but what are the qualifications for a Supreme Court justice? Well, in Article 3, there's really not much. Really, the only couple things it mentions is that a Supreme Court justice serves for life, meaning they're not up for re-election and they can't really be fired. The one qualification is they have to be serving under good behavior, meaning basically they're not doing this. All right, you might be thinking, wait a second, Mr. Lucas, did you say they serve for life, like until they die? Yeah. They do. or at least until they choose to retire. I know what some of you are thinking. It doesn't seem very democratic that we would put people in office for their entire lifetime and never allow the people to elect them or even re-elect them. Well, the Founding Fathers did it for a reason. The Founding Fathers wanted judges on the Supreme Court to be independent, meaning they wanted them to make decisions based off of what the Constitution and the law says, not based off of what the president wants or what the majority of people in an election wants them to do. I mean, let's go back to the referee analogy. Imagine that before the Super Bowl, the NFL let fans of the two teams playing in the Super Bowl vote on who they wanted the referees to be. That's not the smartest decision in the world, because the fans are going to probably vote for the referee that's going to give their team favorable calls, as opposed to maybe being impartial and reffing the game fairly. On the flip side, if you're a referee wanting to officiate the big game, you're probably going to look to see which team has the most fans and then promise that fan base that you'll make favorable calls for their team so that they'll vote you into the game. So you can see why electing judges isn't really the best idea, because a judge's job is not to promise the people things like you see right now going on with this upcoming election and all the political advertisements you get where politicians are promising you this and that. That's not a judge's job. A judge's job is to interpret the law and make sure it's applied fairly. So having judges run for election and re-election can cause them to stray away from what their intended job is supposed to be. And instead of interpreting the law fairly, they may start making favorable calls to one side and promising things they really shouldn't. I mean, can you imagine if judges were running for re-election and they made an advertisement that said something like, "Hi, I'm Judge Lucas. Are you tired of getting in trouble for doing donuts in the parking lot? Vote for me to be judge, and I'll be sure you get off scot-free." Even though the law says you should get in trouble for it, it's about freedom, man. I'm sure a lot of you would vote for that. But again, that's not the job of a judge. God forbid any of you do end up going to court someday. Don't get mad at the judge for sentencing you to pay a fine or ruling against you. It's not the judge's job to change the law. Get mad at the legislative branch. The legislature is the one who made the law. The judge's job is just to operate based off of what the law says. So the Founding Fathers wanted the judicial branch and judges on the Supreme Court to be insulated from the world of politics. The Founding Fathers reinforced that notion of independency in two other ways in Article 3. Number one, the Supreme Court justice can't be fired by the president just because they rule in a way that they don't like. Supreme Court justices can be impeached, but as you learn with the president's impeachment process, that's really hard to do. They can only be impeached for bad behavior. What that means? Well, again, that's kind of vague in the Constitution. Secondly, they cannot have their salary reduced. I mean, think about it. Congress and the president may try to reduce the salary of the Supreme Court if the Supreme Court ruled in a way that they didn't like. So this prevents them from having that fear that they may get a big salary cut if they rule in a certain way, and preserves that independence of the court. So the fact that judges are on the court for life and they're almost untouchable makes selecting judges really, really important. And that leads us to the question of, how are judges even selected to go onto the court? Well, we kind of went over it last week in our lesson on the president. Anytime there's a death or someone decides to resign and retire from the court, the president gets to pick someone to go onto the Supreme Court. The first thing the president does whenever they're about to nominate a Supreme Court justice is they try to find someone who has experience already being a judge. And they'll often pick judges that are judges of inferior courts or the courts underneath the Supreme Court. Resume matters, and so presidents often try to pick people that have graduated from Harvard and Yale law schools, which are both the top law schools in the entire country. So after whittling down the pool of candidates based off of their experience and resume, the next thing the presidents usually look at is their judicial philosophy. That phrase judicial philosophy simply refers to how a person believes a judge should act and how they should interpret the Constitution. Generally speaking, there are two different types of judicial philosophies. The first we'll take a look at is called loose constructionism. Judges that interpret the Constitution loosely believe the Constitution is like a living document, meaning that it can change over time as the times change. So you don't have to formally change the Constitution, but what's already written there can be interpreted differently as the times progress. Constructionism is essentially the idea that the Constitution gives the federal government broad powers to deal with any issue they may need to deal with. Loose constructionists believe the government should do what's best for the entire nation, even if it's not explicitly, specifically written in the Constitution. Let me give you an example. The Constitution doesn't say anything about healthcare, but the government is heavily involved in healthcare. So a loose constructionist would look at the Constitution, and even though they don't see healthcare in there, if the government's involved in healthcare to promote the general welfare of society, then a loose constructionist would say it's perfectly fine for government to be involved in healthcare, even though the Constitution doesn't necessarily say that they're allowed to. Judges that interpret the Constitution loosely often rely on two parts of the Constitution we went over a couple weeks ago, the Commerce Clause and the Necessary and Proper Clause. Remember, those two clauses give Congress some broad powers. It allows them to do things that may not specifically be mentioned in the Constitution. So the idea of a living Constitution is the idea that as society and culture changes over time and technology changes, the Constitution doesn't necessarily have to be formally changed. Rather, it's the job of judges to interpret and update its meaning as the times change. And it's so broad that it allows Congress to act without having to be tied down to the wording of the Constitution. Most judges that are loose constructionists are considered liberal judges. And usually whenever a Democrat is president, they're going to want to pick a loose constructionist or a liberal judge. And that makes sense because most Democrats believe the role of government should be bigger, that government should have more power. And so obviously Democratic presidents are going to want to pick a judge that more closely aligns to that and believes that the government does have some more broad powers than is perhaps mentioned in the Constitution. On the flip side, you have strict constructionists. And strict constructionists are usually conservative judges. And these are the types of judges that Republican presidents like to pick. Like Republicans, strict constructionist judges believe that the federal government has very limited power. Strict constructionist judges believe that the federal government can only do what the Constitution specifically says they can do. That's why they're sometimes referred to as textualist or originalist, because they believe the Constitution should be interpreted strictly by what the original intent of the text was. That means if the federal government's doing something that's not specifically mentioned in the Constitution or doesn't fit under the Commerce Clause or the Necessary and Proper Clause, then a strict constructionist judge is going to strike that down and say it's unconstitutional because it's not in the Constitution. Whenever there's a case before them, they often ask themselves, what would the founding fathers have said about this case? And they use that as their guiding principle in their ruling. So strict constructionist says, sure, the Constitution can change, but you have to go through the formal amendment process. If society wants to update the Constitution because culture or technology has changed, they still have an avenue to do that by adding an amendment to the Constitution. From their point of view, it's not the job of the court to change the Constitution, because after all, they're not elected. Who's to say that they are a good judge of what society wants the Constitution to be changed to? So a strict constructionist will say it's the job of the legislative branch to change the Constitution formally. It's not the job of the judicial branch to also be making new policies. You'll often hear constructionist judges argue that it was the original intent of the founding fathers to have separation of powers, where the legislative branch makes laws and policies, executive branch enforces them, and the judicial branch interprets the law and settles disputes. It's not the job of the judicial branch to be making policy. That's the original function of the legislative branch. So to summarize that, loose constructionists believe that the Constitution is evolving, whereas strict constructionists or originalists believe that the Constitution should be interpreted based off of the original intent of the Constitution. A perfect modern example of where you can see the split in judicial philosophy is with the Second Amendment. Strict constructionists view the Second Amendment in its original light. What was the original intention behind the Second Amendment? And they often read it as to say that the people should be able to have firearms so that they can overthrow their government if it becomes tyrannical. Therefore, the federal government should not be allowed to ban or regulate or restrict most firearms. Whereas loose constructionists, they will look at the Second Amendment and think that it needs to kind of be updated with the times. Weaponry has changed. And so since it's government's duty to protect the people, government should therefore be allowed to regulate what types of firearms people can and cannot have. And therefore, they kind of have a broader view of the Second Amendment and interpret it in a way that does give the federal government power to maybe ban certain types of weapons. So back to that whole nomination process. Once a president knows a person's judicial philosophy, if it's one that they agree with, they will then choose that person to be a nominee to the Supreme Court. After the recent death of Ruth Bader Ginsburg, there was a vacancy on the Supreme Court. So President Trump has selected Amy Coney Barrett to replace Ruth Bader Ginsburg on the Supreme Court. Obviously, President Trump looked at her resume. He looked at her judicial philosophy, and her judicial philosophy is that of a strict constructionist, which is the type of judge that conservatives or Republicans really like. So now that President Trump made his pick, the next step for Amy is to go through the hearing process. The hearing process is tough. The nominee has to go before the Senate and answer a ton of questions where the Senate's going to grill them on what they might do if they see a certain scenario or a certain case that comes before them on the court. They want to get an idea of their judicial philosophy and how they might rule on things. And it's really important to them because this is the only say the legislative branch gets in that pick. And whoever ends up being on the court is there for life. Remember that clause in Article 3 that said justices have to be in good behavior? They will also look up everything you've ever done in your life and ask you about it to make sure that you are a good person and you will be an honorable justice. The last justice to go through this process, Justice Brett Kavanaugh, had some accusations of sexual assault in his past that were brought up by Democrats in the Senate Judiciary Committee. And it made for some pretty intense moments in those hearings.
Not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman,
I
with this
extend a
hearing.
very warm welcome.
Constitution gives the Senate an important role in the confirmation process, but you have replaced advice and consent with search and destroy. Since my nomination in July, there's been a frenzy on the left to come up with something, anything, to block my confirmation.
If you wanted an FBI investigation, you could have come to us. What you want to do is destroy this guy's life, hold this seat open, and hope you win in 2020. You've said that, not me.
Justice Kavanaugh ended up getting confirmed, but as you saw there, it was a very, very big political spectacle. And that's been happening more and more recently, where Democrats really went after Brett Kavanaugh there and Republicans really tried to defend him. There's going to be at least one party in the Senate, whether it be the Democrats or the Republicans, that doesn't want you to be on the court. In Amy Coney Barrett's case, it's the Democrats in the Senate that don't want to confirm her onto the court because she interprets the Constitution in a strict way. They want a judge that interprets the Constitution in a loose way. So they're going to do everything they can to try to make sure that she does not get on the Supreme Court. They're going to try to ask her tough questions that might make her look bad or might make her say something that she ends up regretting, and then they can take that and run with it. But if you survive the hearing, then it goes to a vote, and the Senate can approve or reject a Supreme Court nominee by a simple majority. If they're approved, hey, congratulations, you're on the court for life. If they're rejected by the Senate, though, then the president has to pick someone else. In case you haven't noticed, everyone's been talking a lot about Amy Coney Barrett being nominated to the Supreme Court. Why? Well, it's an election year. So Democrats want to do everything they can to stall the process in hopes that Joe Biden wins the election. And if there's no Supreme Court justice that's been officially nominated and approved by the Senate, then Joe Biden would get to make that pick next year. But if President Trump is able to get Amy Coney Barrett onto the Supreme Court, even if he loses the election, that's one more conservative justice on the Supreme Court that's there for life. As I make this video right now, it looks like the Senate Judiciary Committee is planning on holding Amy Coney Barrett's hearings beginning Monday, October 12th, which I think is the day that this Edpuzzle is assigned. So if that's the case, the vote for confirming or rejecting Amy Coney Barrett will likely be within the next few weeks. Right now, Republicans barely have a majority in the Senate, which means it's likely that they would indeed confirm her to the Supreme Court, and she would be Trump's third Supreme Court nominee to make it onto the court. But fully expect Democrats to put up a really tough fight like they did last time with Brett Kavanaugh. Confirmation hearings have recently become a big opportunity for politicians to make a name for themselves. Who knows, if you do well enough and make a big enough name for yourself, people might start talking about you for the presidency. And it might just work out. For example, Kamala Harris was one of the prominent Democratic senators that went after Brett Kavanaugh, and here she is as Joe Biden's vice presidential running mate. Wow, how crazy would that be? If she does end up becoming vice president, Brett Kavanaugh might be in a position to strike down some of Biden and Harris's policies as unconstitutional. Ooh, drama. We'll have to see how it all plays out, because if she does end up being confirmed to the Supreme Court, she would make the 6th Supreme Court justice that's a conservative, leaving only 3 liberals on the court. Remember, they serve for life, so that means maybe for the next 20 to 30 years, the court will lean conservative, meaning it's going to interpret the Constitution with that strict constructionism. But if you're conservative, that's great, because it means the Supreme Court is likely going to be ruling pro-life and pro-Second Amendment for quite some time. But if you're a liberal, that means the court is likely going to be ruling in ways that you may not like. But don't worry, if you're a liberal, some Democrats in Congress have thought of some sneaky ways to actually maybe get the court to have a liberal majority. If you go back to Article 3, you'll notice in there, it doesn't say how many justices have to be on the court. In fact, we haven't always had 9 justices on the court. So it is possible that Congress could change the number of justices to the Supreme Court, and they could add seats onto it, which means maybe they could add 3, 4, or 5 more seats onto the Supreme Court if Joe Biden becomes president, and then he can pick liberal justices that interpret the Constitution loosely, and then suddenly you have a liberal majority on the Supreme Court. This is called court packing. Another idea some Democrats in Congress have had is to add a constitutional amendment to the Constitution that would put term limits on judges, where maybe after 18 years or so, they would be up for re-election. Or maybe after 18 years, they would have to be replaced by whatever president is in power and whatever Senate is in power at that point. So there's lots of different ideas out there floating right now amongst Democratic congressmen who are trying to stop the Supreme Court from having a conservative majority for the next 20 to 30 years, because that likely means if there's ever a Democratic president or Democratic majority in Congress within the next 20 to 30 years, some of their policies might get struck down by that conservative Supreme Court. Right now, a lot of Democrats have been arguing that President Trump should wait until after the election to appoint a new Supreme Court justice. Obviously, they're hoping that Joe Biden wins the election and can appoint the next Supreme Court justice. But their argument is, hey, if you win next time, that's basically the United States saying, you know what, Trump, we want you to stay in and we want you to appoint the next Supreme Court justice. And if that's the case, well, then you can do that then. Of course, President Trump wants to get it done right now. He's arguing there's nothing in the Constitution that says he has to wait until after an election. If you look at Article 3, it says whenever there's a vacancy, the president can appoint someone to the court. Obviously, President Trump wants to appoint someone right now to secure that conservative majority for a long time, because as it stands, President Trump's polling numbers aren't looking very good right now. Now, of course, anything could happen in the next month, but as we speak now, his re-election chances aren't looking super great. So let's go ahead and meet the 8 justices that are currently on the Supreme Court right now. Let's start with the liberal wing of the court. There's Stephen Breyer, who is 82 years old and was appointed to the court in the 1990s. There's also Sonia Sotomayor, who's the first Hispanic and Latina woman to ever be on the Supreme Court, and Elena Kagan. Both of them are liberal justices as well, and they were appointed by Barack Obama. On the conservative end of the court, you have Neil Gorsuch and Brett Kavanaugh, both of which were picks by President Trump. Also on the conservative side is Justice Samuel Alito and Justice Clarence Thomas, who's probably the most conservative member of the entire court. Then there's the Chief Justice, and the Chief Justice is basically the highest ranking member of the court. The current Chief Justice is John Roberts. And John Roberts, even though he was appointed by a Republican president and is considered a conservative justice by some, he's actually the swing justice. And just like we talked about a swing state a couple weeks ago, a swing justice is a justice that sometimes votes with the liberals and sometimes votes with the conservatives. Whenever there's a case, you're not entirely sure which direction he's going to go. It means he frequently makes one side really happy and then one side really, really mad. So we've been over kind of all the big picture stuff about the court, but what does it actually look like when they get a case before them? First of all, there are thousands of cases that are appealed to the Supreme Court, but obviously they don't have time to hear thousands of cases. So they get to choose which cases they hear, and they'll try to pick cases that they think are really important and need an answer on. After that, they'll bring lawyers in from both sides of the issue and have them argue the case. Now, the justices can interrupt them in the middle of their argument and ask them questions, or they might even argue back with them. Not only are they trying to maybe clarify the case for themselves, but they also might do it in a way that stumps the lawyers and maybe brings up a really good point that might make one of the other justices change their opinion. You never know, it might make one of them think, that's a good point. I didn't think of that. Some of the justices are known for talking far more than other justices. For example, Clarence Thomas, never says anything during an oral argument. He never asks questions, but on the rare occasion that he does, everyone stops and goes, oh my gosh, did he just say something? Good life lesson. If you don't talk much, everyone will drop everything to listen to you when you finally do. Now, during oral arguments, no cameras or video recording equipment is allowed into the courtroom at all whatsoever. They do record the arguments and then they post them about a week later on their website, but no one is allowed to take pictures of the Supreme Court. In fact, it's been done only a couple times by someone that smuggled a camera into the Supreme Court to take a picture of it, but the only time you'll ever see a visual perception of what happened is with Supreme Court sketches. You might be thinking, wait, why won't they let cameras into the court? Well, I'll let the Chief Justice himself explain that one to you.
I think it'd be very helpful in getting more people familiar with how the court operates, but that's not our job to educate people. Our job is to carry out our role under the Constitution to interpret the Constitution and laws according to the rule of law. And I think that having cameras in the courtroom would impede that process. We think the process works pretty well. I think if there were cameras, that the lawyers would act differently. I think, frankly, some of my colleagues would act differently. And that would affect what we think is a very important and well-functioning part of the decision process. I don't think there are a lot of public institutions, frankly, that have been improved in how they do business by cameras. Senator Howard Baker told me at one point that he thought the televising of the Senate proceedings, I think he used a strong word, I'm sure it's not right, whether it's ruined or certainly hurt the proceedings in the Senate.
I don't know, maybe he's got a point. Can you think of any examples of that? Anyway, here's an oral argument from a case from a few years ago. In this case, a Christian bake shop was sued by a gay couple who had ordered a cake from the shop for their wedding. The Christian couple that owned the bakery claimed that they refused to bake the cake for the wedding because it violated their religious beliefs. They believed that marriage was between one man and one woman, and being forced to bake a cake for a gay wedding was something they felt was wrong. The gay couple claimed that they were being discriminated against for being gay, and under Colorado law, businesses are not allowed to discriminate against someone based off of their identity, whether that be sexual orientation, gender, religion, or whatever. Whew, so this is a tough case because you've got a lot at play here. You have freedom of religion, freedom of expression, and private property rights to do what you want with your own property, in this case, a cake. And then you also have people claiming they have a right not to be discriminated against, and that's backed up by Colorado law. So who's right here? So let's jump into the oral arguments here. In this particular clip, you'll hear from one of the lawyers that's defending the gay couple being questioned by Supreme Court Justice Neil Gorsuch, who's going to ask him a really tough question.
Let me make it clear. I am not advocating this exception at all. I am just saying that this case does not involve that kind of participation, and so you don't need to address it. If at some point a case arises, then
let's take a case a little bit more like ours, and it doesn't involve words, but just a cake. It is a Red Cross, and the baker serves someone who wants a Red Cross to celebrate the anniversary of a great humanitarian organization. Next person comes in, wants the same Red Cross to celebrate the KKK. Does the baker have to sell to the second customer? And if not, why not?
It's not identity-based discrimination. All that Colorado law and public accommodations law generally requires is that you not discriminate on the basis of particular protected classes, sexual orientation, race, disability, religion, and the like. And if I can go back to Justice Alito's question.
Well, why is that any different than our case? You say it's not based on identity, but Baker might well say, I despise people who adhere to the creed of the KKK. That's one way of characterizing it. Another way of characterizing it is saying I disagree with the message of the KKK. So too here. One could make the exact analogy, I would think, that you could either characterize it as I don't like people of a certain class, or I have a religious belief against this kind of union. So how do I distinguish those cases?
I think, Your Honor, if
That was a tough question, because Gorsuch is essentially asking, well, how's this any different than someone saying, you know what, I don't want to bake a cake for someone that's wanting to celebrate the KKK with that cake. The lawyer fired back and argued, hey, well, that's not discrimination based off of identity. But Gorsuch counter-argued that and said, wait a second. Actually, it's really hard to distinguish someone's identity from their beliefs. After that, even one of the liberal justices at the time, Anthony Kennedy, jumped in and said, that's a good point.
This whole concept of identity is slightly confusing. Suppose he says, look, I have nothing against gay people. He said, well, I just don't think they should have a marriage because that's contrary to my beliefs. It's not their identity, it's what they're doing. I think your identity thing is just too facile.
So after the oral argument, the judges all get together and they discuss the case. Then they'll take a vote on whose side they're voting in favor of. In that particular case, the justices voted 7-2 in favor of the Christian couple who owned the bakery. And it's quite possible that Neil Gorsuch's question there actually may have caused some of the liberal justices to side with the conservatives in that case. Things like that do happen from time to time. In fact, this past year, some of the liberal justices got Neil Gorsuch to side with them on a particular case. So after the justices vote, they'll then write up their opinion on the case, which is where they give not only their final decision, but also the reasoning behind why they voted the way that they did. If they voted with the majority opinion, it's called the majority opinion. If they voted against the majority opinion, meaning they were in the minority, it's called a dissenting opinion, meaning that they disagreed with the final decision. Then there's a concurring opinion. And a concurring opinion means you agree with the final decision, but you had different reasoning as to why you arrived at that conclusion. So after the court makes a ruling, they then have to rely on the executive branch to actually enforce the ruling. And the executive branch doesn't always do that. This is just part of separation of powers. Because the judicial branch doesn't have an enforcement mechanism as a way to force people to actually follow their rulings, it kind of makes them the weakest branch of the three branches of government. And that's pretty much what you need to know about Article 3 of the Constitution and the Supreme Court. As for your assignments this week, you guessed it. You've got 2 Ed puzzles, both of which are due Wednesday, and then 1 Google form, which is due on Thursday. Order, class is adjourned.